My name's Douglas Wemyss, I'm a solicitor, and I'd like to say a few words to you about renewal of commercial leases. If you have a business lease that's about to come to an end, you don't necessarily have to leave the premises, and you may well be entitled to demand a new lease on better terms. The Landlord Tenant Act 1954 raises a presumption that a tenant who occupies the premises for their own business has a right to a fresh lease on similar but updated terms to their present lease. The type of terms that will be updated are the market rent and any other terms which perhaps reflect recent changes in the law or general market practice. A tenant should always check whether their lease has the benefit of the protection of the 1954 Act. Generally speaking, a lease will have that protection unless either a court order or certain other notices warning that the lease is excluded from the protection of the Act have been served on the tenant prior to the tenant entering into the original lease. If you're not the original tenant, i.e. you acquired the lease partway through its term, and if you can't remember whether the Act applies, then it's worth checking the lease, because if it has been excluded from the protection of the Act, a brief paragraph to that effect should appear somewhere within the lease. Provided you have the protection of the Act, the lease will not automatically come to an end unless you either voluntarily choose to leave or, before the expiry of the term, the landlord has served notice of at least 6 months on you, asking you to quit in a form expressly prescribed by the law. If the landlord serves that notice to quit and you want to stay on, you should take advice if you don't want to lose your tenancy, because there are strict deadlines to be complied with, even if the landlord has offered to let you have a new lease. If you have not had notice served on you and simply stay on at the premises, you'll enter into a period known as holding over. In effect, this means that all the terms of the lease that were applicable at the end of the original lease, such as, for example, the passing rental, will continue to have the same effect until either you vacate the premises or a new lease is agreed or granted by the court. There are dangers for a tenant who wants to stay on for just a few days after the end of the original term. Once you enter into the holding over period, if a tenant wishes to quit, they must serve on the landlord a notice, and the length of the notice required is a payment period. The notice must also expire at the end of a payment period, so that if the rent is paid quarterly, then the payment period is 1 quarter, i.e. 3 months. The quarter dates are Christmas Day, 25th March, 24th June and 29th September. If, for example, the tenant tried to break out of a holding over period in January, the earliest possible date that notice to quit could expire would be the 23rd of June. Holding over has the advantage that the tenant doesn't necessarily have to make the longer commitment to a fresh lease. But on the other hand, a tenant may want the certainty of having a fresh lease. Either the tenant or the landlord may apply to the court for a new lease to be granted. In current market conditions, a tenant wishing to stay on may well wish to make their application to the court as quickly as possible if the market rental is less than their present rental under the lease. This is because, unlike a rent review within a lease, which is almost invariably on an upward-only basis, the court can and will grant a lease at lower than the current rental if the market rental is lower. The majority of the commercial property sector is now achieving rentals significantly lower than that which was being achieved 3 years ago. The expiry of a lease could therefore be a perfect opportunity for a tenant to force their landlord to agree to a new lease at a reduced rent. I hope those thoughts are helpful. Thank you for listening.